all of the government motions as on the amendment paper. I call the Minister to move the motion to disagree with Lord's amendments 1B, 7B and 90D. Minister Jenrick.
Thank you, Mr. Speaker, and I beg to move that this House disagrees with Lord's amendments 1B, 7B and 90D. Mr. Speaker, last Tuesday, this House voted 18 times, more times than in any other day on any other given piece of legislation, and 18 times this House voted to support this bill. Mr. Speaker, the House of, if I may make a few opening remarks. Mr. Speaker, this House sent back to the House of Lords their 20 amendments to the bill, many of them simply driving a coach and horses through the fabric of the legislation. We brought forward reasonable amendments where it was sensible to do so, and it's disappointing, to say the least, that some of these have been rejected. I welcome the fact that the 20 issues we debated last week have now been whittled down to 9, but the issue now before the House is whether the clearly expressed views of this House, the elected chamber, not just in the vote last week, but throughout the earlier passage of the bill, should prevail. We believe that inaction is not an option, that we must stop the boats, and that this bill is a key part of our plan to do just that. The message and the means must be absolutely clear and unambiguous. If you come to the UK illegally, you won't be able to stay here. Instead, you'll be detained and returned to your home country or removed to a safe third country. There is simply no point in passing legislation that does not deliver a credible deterrent and provides the means to back it up with effective and swift enforcement powers. We can't accept amendments that provide for exceptions, qualifications and loopholes which would simply perpetuate the current cycle of delays and endless late and repeated legal challenges to removal. I listened carefully to the debate in the other place, but Mr. Speaker, no new arguments were forthcoming and certainly no credible alternatives were provided. I'll give way.
May I say I thoroughly endorse what my right honourable friend has said. This is a matter of extreme national interest. It is also reflected in the votes of people in the constituencies throughout the country. They feel very strongly about these matters. Does he not agree that it is time for their lordships to take note of the fact that the British people want this legislation to go through because they want progress given the extreme difficulties that it's presenting to the British people?
Well, I strongly endorse the comments from my honourable friend. This is an issue of the highest importance to the public, the people that we serve in this place. Of course there is a legitimate role for the other place in scrutinising legislation, but now is the time to move forwards, to pass this law and enable us to stop the boats. I'll give way to the right honourable gentleman.
I wonder if my right honourable friend noticed the remarks by Lord Clark, not a particularly vicious right-wing creature, who said that this bill was entirely necessary and we had to get on with it. And I wonder whether he also looked at the remarks of Lord Heseltine, actually, today. And between the two of them, they seem to have a sensible option. Go ahead with this bill. We have to have much better European cooperation and really build a wall around Europe. And we have to do much more, and this is what the other side might like, we have to do much more in terms of a Marshall Plan to try and remove the conditions of sheer misery which causes people to want to leave these countries in the first place.
Well, I did read the remarks of the noble Lord Clark, and I entirely agree with the point that he was making, which was that having listened to the totality of the debate in the House of Lords, he did not hear a single credible alternative to the government's plan, and so for that reason alone it is important to support the government. I also agree with the broader point that he's making, that this policy should not be the totality of our response to this challenge. Deterrent is an absolutely essential part of the plan, But also, we need to be working closely with our partners in Europe and further upstream. And one of the initiatives that the Prime Minister, the Home Secretary, and I have sought to do in recent months is to ensure that the United Kingdom is a strategic partner to each and every country who shares our determination to tackle that issue, from Turkey to Tunisia to France to Belgium. I'll give way to the right honourable gentleman.
I'm grateful to my honourable friend, and I completely agree with him. I agree that the bill should go through. We have to do something about the deaths that take place in the Channel, and that's an important moral purpose. But can I just bring him back to the issue of Lord Randall's amendment on modern-day slavery? We kind of agree quite a lot on this issue, and the government has said that they will do stuff in guidance. So what he has done is taken the very words that my honourable friend has said at the dispatch box and bound them back in to the face of the bill, exactly what my honourable friend promised they would do in guidance. Now, the government hasn't issued the guidance in detail, and so this is why it is here. Could he answer why would we vote against that today when those are his words, those are his prescriptions, and they are now on the face of the bill?
Well, let me turn to that issue first up then. And I'd say two things in response. Firstly, what the Lord's amendment on modern slavery is seeking to do does go further and does make the scheme as we see it much more difficult to establish. And that's for a number of reasons, but in particular that we think that the complexity of this issue requires the assurances that I've made on the floor of this House to be provided in statutory guidance rather than on the face of the bill. And one of those assurances in particular is particularly challenging to put in statutory guidance, and that is the point that he has helpfully tried to bring forward, which is to do with incidents that have taken place in the United Kingdom rather than in an individual being trafficked here. We're clear that the process that I've set out should be set out in statutory guidance because the wording of the amendment is open to abuse by those looking to exploit loopholes. Those arriving in small boats will seek to argue that they've been trafficked into the UK and that the 30-day grace period should apply to them on the basis that they qualify as soon as they reach UK territorial waters. This is... Well, let me just finish making this point to my right honourable friend. The provision proposed is, for that reason, operationally impossible and only serves to create another loophole which renders the swift removal that we seek impossible or impractical. The statutory guidance can better describe and qualify this commitment by making it clear that the exploitation must have occurred once they've spent a period of time within the United Kingdom and not immediately when they get off the small boat in Kent. So for that reason, we consider it better to place this guidance on a statutory footing as guidance rather than on the face of the bill. I'll come to the Honourable Lady. I'll give way to the Honourable Gentleman first.
Thank the Minister very much for that. The Democratic Unionist Party, our party, are very much very keen to ensure and are concerned over the trafficking of children and indeed young people. I think, Minister, the question I want to ask, if I can, is a quite simple one. Those who are economic migrants who are fit and healthy but nonetheless make that journey, and those who have been persecuted, have had to leave their country, discriminated, had to leave their country, have been brutal violence against them, had to leave their country, had people who were murdered, family members. I just want to be assured, if I can, and my party wants to be assured, that those who flee persecution have the protection within this law, because we don't see that they have.
Well, they don't.
No, that's a point.
Well, we believe that they do, because at the heart of the scheme is the principle that if an individual comes to the United Kingdom illegally on a small boat, then they will be removed back home, if it is safe to do so, to a safe home country, such as Albania. And in determining that country safe, for example, in the case of Albania, we would have sought specific assurances from it, if required, or to a safe third country, such as Rwanda, where again, we would have sought sufficient assurances that an individual would be well treated there. And as the Honourable General can see in the court's at the moment, those assurances will no doubt be tested thoroughly. So it's not the intention of the UK government to expose any genuine victim of persecution to difficulties by removing them either back home and in the process refouling them, or to a country in which they would be unsafe. What we do want to do is establish a very significant deterrent to stop people coming in the first place, bearing in mind that the overwhelming majority of the individuals that we're talking about who would be caught by this bill were already in a place of safety. They were in France, a clearly safe country with a fully functioning asylum system. I'll give way to the Honourable Lady and then I should make progress.
For giving way, I wanted to take him back to the criticism he was making of the other place, because it seems to me that if the elected House is about to break international law, then it is entirely fitting that the other place should try to stop that from happening. The Minister stood at the dispatch box telling us this bill is about deterrence, whereas the Home Office's own impact assessment has said that the bill is a novel and untested scheme. It's therefore uncertain what level of deterrence it will have. And as a raft of children's charities have pointed out, that once routine child detention was entered in 2011, there was no proportional increase in children claiming asylum. So will he come clean and accept that this bill absolutely will have the effect, even if it doesn't have the intention, of meaning that those people who are trying to escape persecution will not be able to come here because there are not sufficient safe and legal routes?
Well, I'm not sure exactly what the Honourable Lady's question was, but if it is regarding access to safe and legal routes, let me be clear again, as I have in numerous debates on this topic. Since 2015, the United Kingdom has welcomed over 500,000, nearer to 550,000 now, individuals here for humanitarian purposes. That's a very large number of individuals. The last statistics that I saw, we were only behind the United States, Canada and Sweden for our global UN-managed safe and legal route, and we were one of the world's largest countries for resettlement schemes. That's a very proud record. The greatest inhibitor today to the UK doing more on safe or legal routes are the number of people coming across the Channel illegally on small boats, taking the capacity in our asylum and immigration system, which she knows only too well, because she and I have discussed on a number of occasions one of the most concerning symptoms of this issue, which is unaccompanied children who are having to stay in a Home Office procured hotel near to her constituency because local authorities don't have capacity to flow those individuals into safe and loving foster care as quickly as we would wish. So that issue is exactly emblematic of the problem that we're trying to fix. Stop the small boats, then we can do more as a country, be an even greater force for good in the world. I'll give way, but then I must make progress. It's a short debate.
To the Minister giving way, perhaps he could set out how my constituent will be protected. He's Albanian. He has been subject to modern slavery by gangs from Albania. He has 3 bullet holes in his body, and those gangs, if he returns, perhaps will give him more. How will he be protected?
Well, under the existing arrangement that we have secured with Albania, which incidentally is a signatory to the European Convention Against Trafficking, enables us to safely return somebody home to Albania with specific assurances to prevent them being re-trafficked to the United Kingdom and to enable them to be supported appropriately upon arrival. On the broader issue of modern slavery, the bill makes a number of important protections when we establish this scheme. In the first instance, it means that if they are a party to a law enforcement investigation, then their removal from the country would be stayed, and we've said that we're going to bring forward statutory guidance, giving them a 30-day period, allied to the period set out in ECAT, for them to come forward and to work with law enforcement, which is extendable if that enforcement activity goes on for some time, and that we would then only remove that person either back home to a safe country such as Albania or to a country such as Rwanda, where we've put in place appropriate procedures to ensure that that government in turn looks after them. And I'd point the lady to the judgment in the Court of Appeal, which made some criticisms of the government's approach, but did not say that the arrangements in Rwanda with respect of modern slaves were inappropriate. It supported the government in that regard. And so we will clearly put in place appropriate procedures to ensure that victims such as the one that she's referring to are properly supported. I'll give way, and then I must finish my remarks.
I thank the Minister for giving way. In terms of many of the opponents of this bill who talk about safe and legal routes, many of them seem to support uncapped safe and legal routes. The reality of this would be that potentially over 1 million people could actually get the ability to come here. Does the Minister agree that those proposing this should be open and honest about this and also explain what the consequences, the dramatic consequences would be for public services and community cohesion in this country?
Well, I completely agree, and anyone who feels that this country has sufficient resource to welcome in very significant further numbers of individuals at the present time should look at the inbox of the Minister for Immigration, because it is full of emails and letters from members of the public, from local authorities and members of Parliament on both sides of this House complaining that they don't want to see further dispersal accommodation, worried about GP surgery appointments, worried about pressure on local public services, worried about further hotels. And I understand all of those concerns. That's why we need an honest debate about this issue. That's why at the heart of this bill is not only a tough deterrent position for new illegal entrants, but is a consultation on safe and legal routes where we specifically ask local authorities, what is your true capacity? And so if we bring forward further safe and legal routes, they will be rooted in capacity in local authorities. So those individuals are not destined for months or years in hotels, but go straight to housing and support in local authorities. That must be the right way for us to live up to our international obligations, rather than the present situation, which all too often is performative here and then major problems down the road. Let me just briefly reply to the amendments that are before us, other than the one we've just discussed on modern slavery. On the issue of detention, we do believe it's a necessary part of the scheme, provided for in the bill that there are strong powers. Where those subject to removal are not detained, the prospects of being able to effect removal are very significantly reduced, given the likelihood of a person absconding, especially towards the end of the process. We have made changes to the provision for pregnant women, which I'm pleased have been accepted by the Lords, and unaccompanied children. But it's necessary for the powers to cover family groups, as to do otherwise would introduce a gaping hole in the scheme, as adult migrants and the most disgusting people smugglers would seek to profit from migrants and look to co-opt unaccompanied children into bogus family groups to avoid detention. This not only prevents the removal of the adults, but presents a very real safeguarding risk to children. As regards unaccompanied children, we stand by the amendments agreed by this House last week. They provided for a clear differentiation between the arrangements for the detention of adults and unaccompanied children. The amendments agreed by this House provide for judicial oversight after 8 days detention, where that detention is for the purpose of removal. On the standards of accommodation, I've made clear that unaccompanied children, including those whose age is disputed, will only be detained in age-appropriate accommodation, and that existing secondary legislation, the Detention Centre Rules 2001, set out important principles governing the standards of such accommodation. Last week, some members asked whether unaccompanied children would also receive age-appropriate care while in detention. The answer to that is an emphatic yes. The operating standards for immigration removal centres contain provisions around the treatment of children, including requirements on the educational and play facilities that must be provided for children. I'll give way on that point, Don Mullally.
Thank him for giving way. I'd like to thank him for making it clear that unaccompanied children, if there's any doubt about their age, they will be treated as a child. I'd like him to thank him for saying that if a child is detained, it will be in an age-appropriate centre. But on the issue of what is age-appropriate, I've just looked at those operating standards he referred to. It's an 82-page document. It has no mention of unaccompanied children. It talks about who looks after the locks and hinges, where the tools and the ladders are to be stored, but it has nothing about how we keep these children happy, healthy and safe from harm. So I would instead point him to the guidance that we have for children's care homes and ask him gently if we could update the rules we have on detention centres to make sure that they look more like the rules we have for safeguarding children in care homes. Thank you.
Well, I'm grateful to the Right Honourable Lady, and she makes a number of important points. The guidance is very detailed, but I'm sure that it would benefit from updating. And so the points that she's made and those that other honourable and right members across the House have made in the past will be noted by officials in the Home Office. As we operationalise this policy, we will be careful to take those into consideration, because we're all united in our shared belief that those young people who are in our care need to be treated appropriately. Madam Deputy Speaker, turning to the Lord's amendments on modern slavery, I hope that I've answered the comments from my right honourable friend. These seek to enshrine in the bill some of the assurances I provided in my remarks last week in respect of people who are exploited in the UK, but for the reason I've just described, we think that is better done through statutory guidance. In fact, would be impractical, if not impossible, to do on the face of the bill. I'll give way.
He is aware that the Nationality and Borders Act already allows, because the point he made earlier on was that somehow those would be able to get into the UK and make a false claim, but the Nationality and Borders Act actually provides already for that, so anyone found to have made a false claim will then be disqualified, and disqualified quite quickly. And so the key thing here is what I'm worried about, and it is really critical, we want to prosecute those who have been the traffickers. That way we may stop them trafficking people further on the boats. My worry here still remains that this will put off many people from giving evidence and cooperating with the police for fear of the fact they may yet still be overridden and sent abroad while they're doing it, then be picked up by the traffickers. Does he give any credence to that fear that I have got, that this may end up reducing the number of prosecutions of traffickers as a result?
Well, I understand the position that my right friend comes from, and it's absolutely right that he is vocalising that, but we don't believe that that is likely. The provision that we've made in the statutory guidance that I've announced will enable an individual to have 30 days from the positive reasonable grounds decision to confirm that they'll cooperate with an investigation in relation to their exploitation, which should give them a period of time to recover, to come forward, to work with law enforcement. That is a period of time aligned with the provisions of ECAT, and so we rely upon the decision of the drafters of ECAT to choose 30 days rather than another potentially longer period. And that is an extendable period, and so where a person continues to cooperate with such an investigation, they'll be able they'll continue to be entitled to the support and the protections of the NRM for a longer period.
I just want to make the points clear. It's still feasible under the new regulations that the Secretary of State can decide, notwithstanding that even if they are cooperating, that they therefore don't need to remain in the UK for that. And that is the critical bit. They live under the fear that they can be moved somewhere else to give that evidence, which will put off a lot of people from therefore giving that evidence. Does he not agree?
Well, I hope that is not borne out to be the case, because it's worth remembering that we won't be removing anybody to a country in which that individual should be endangered. We would be removing that person either back home to their home country, if it's one where we consider it safe to do so, usually because they're an ECAT signatory and they've got provisions in place, or to a safe third country, such as Rwanda, where once again we will have put in place very significant provisions to support that individual. So I hope that provides those individuals with the confidence to come forward and to work with law enforcement to bring the traffickers to book.
Will you give way one more time?
I will, and then I must close my
Again, on the issue of unaccompanied children, and I'm particularly interested in unaccompanied children when they arrive in this country, because obviously he has tightened up the 8-day period for them on exit. He's, I believe, just agreed with me that the standards for age-appropriate accommodation in these detention centres need to be updated to look more like those that we have for children's homes. Is he prepared to concede that no unaccompanied child should be put in such a detention centre until that update of the regulation has been undertaken.
Well, I understand the point that the Right Honourable Lady is making, but I'm not sure that is necessary, because the detention centre rules 2001 are very explicit in the high standards that they're expecting. They set the overall standard, and then belying them will no doubt be further guidance and support for individuals who are working within the system. If there is work to be done on the latter point, then I think we should do that and take account of the views of the Right Honourable Lady and others who are experts in this field. But the detention centre rules themselves are very explicit in setting high overarching standards for this form of accommodation. That's exactly what we would seek to live up to. In fact, it would be unlawful if the government didn't. I'll give you.
If I may say, the right of access to a social worker, advocacy, and making sure that the child has the care that they particularly need is what we would expect in a children's home. We would expect Ofsted to oversee that and not the prison inspectors. Thank you.
I'm grateful for those points. I mean, social workers will clearly be at the heart of all this work, as they are today. Every setting in which young people are housed by the Home Office has a strong contingent of qualified social workers who support them, whether that be the US hotels that we mentioned earlier or other facilities. And so I'm certain that social workers will be at the heart of developing this policy and then operationalising it in time. Madam Deputy Speaker, their lordships have attempted but failed to smooth the rough edges of their wrecking amendment on legal proceedings, but I think we need to be in no doubt that they are still wrecking amendments. They will tie every removal up in knots and never-ending legal proceedings. It is still the case that the effect of Lord's Amendment 1B is that the various conventions listed in that amendment are being incorporated into our domestic law. An amendment shoehorned into this bill is not the right place to make such a significant constitutional change, and it's right, therefore, that we continue to reject it. I won't actually, because I need to close my remarks. There's a short debate. Turning to Lord's Amendment 9B, this continues to undermine a core component of the bill, that asylum and relevant human rights claims are declared inadmissible. The Lord's Amendment would simply encourage illegal migrants to game the system and drag things out for as long as possible, in the hope that they would become eligible for asylum here. Lord's Amendment 23B brings us back to the issue of the removal of LGBT people to certain countries. The government is a very strong defender of LGBT rights across the globe. There is absolutely no question of sending a national of one of the countries listed in the amendment back to their home country if they fear persecution based on their sexuality. And the bill is equally clear that if an LGBT person were to be issued with a removal notice to a country where they fear persecution on such grounds, or indeed any other grounds, they can make a serious harm suspensive claim and they will not be removed. I won't, because I need to bring my remarks to a close now. Will not be removed until that claim and any appeal has been determined. The concerns underpinning the amendments, as I said previously, are misplaced, and the protections needed are already in the bill. On safe and legal routes, moving to Lord's Amendment 102B, this brings us back to the issue of when new such routes come into operation. The amendment again seeks to enshrine a date in the bill itself. I've now said on 2 occasions at the dispatch box that we aim to implement any proposed new routes as soon as practicable, and in any event by the end of 2024. It's a commitment I've made on behalf of the government, and that being the case, there's simply no need for this amendment, and we shouldn't be delaying the enactment of this bill over such a non-issue. Lord's Amendment 103A, tabled by the opposition, relates to the National Crime Agency. As I said before, this, again, is a non-issue. It's either performative or born out of ignorance and lack of grasp of the detail. The NCA's functions already cover tackling organised immigration crime, and men and women in that service work day in, day out to do just that. So there's absolutely no need to change the statute underlying the organisation. Finally, we have Lord's Amendment 107B, put forward by the Archbishop of Canterbury. This country's proud record of providing a safe haven for over 500,000 people since 2015 is the greatest evidence that we need that the UK is already taking a leading international role in tackling the refugee crisis. This government is already engaged and working tirelessly with international and domestic partners to tackle human trafficking and continues to engage with supporting overseas programmes. We will always work with our international partners and bring forward proposals for additional safe and legal routes where necessary. This amendment, however well-intentioned, remains unnecessary. And as I've said to His Grace, if the Church wishes to play a further role in resettlement, then it could join our community sponsorship scheme, which is an ongoing and global safe and legal route, which, as far as I'm aware, the Church of England is not currently engaged with. Madam Deputy Speaker, this elected House has voted to give the bill a second and third reading. Last Tuesday, it voted no less than 17 times in succession to reject the Lord's Amendment and an 18th time to endorse the government amendments in lieu relating to the detention of unaccompanied children. It's time for the clear view of the elected House to prevail. I invite all right honourable and honourable members to stand with the government in upholding the will of the democratically elected Commons, to support the government motions and to get on with securing our borders and stopping the boats. I beg to move.
The question is that this House disagrees with the Lords in their amendments 1B, 7B and 90D. Mr Stephen Kinnock.
Thank you very much, Madam Deputy Speaker. On Tuesday, I described the way in which this government has taken a sledgehammer to our asylum system. And I outlined the massive and far-reaching costs and consequences of 13 years of Tory incompetence and indifference. I described this bigger backlog bill as a shambolic farce that will only compound the chaos that ministers have created. I urged the government to accept the amendments proposed by the other place and to adopt Labour's pragmatic, realistic and workable five-point plan to stop the boats and fix our broken asylum system. And I set out how the bill's unworkability centres on the fact that it orders the Home Secretary to detain asylum seekers where there is nowhere to detain them, because it prevents her from processing and returning failed asylum seekers who have crossed the Channel to their country of origin, instead forcing her to return them to a third country like Rwanda. And yet Rwanda can only take 0.3% of those who came here on a small boat last year. So the Rwanda plan is neither credible nor workable, because the tiny risk of being sent to Kigali will not deter those who have already risked life and limb to make dangerous journeys across the continent. But here we are again today, Madam Deputy Speaker, responding to the realisation that in their typically arrogant and tin-eared fashion, ministers are once again refusing to listen. They're once again closing their eyes and ears to the reality of what's happening around them and choosing to carry on driving the car straight into a brick wall. But we on these benches refuse to give up, Madam Deputy Speaker. We shall continue in our attempts to persuade the government to come to its senses. And I shall seek to do that today by setting out why the arguments that the Immigration Minister has made against the amendments that have come to us from the other place are both fundamentally flawed and dangerously counterproductive. Turning first, I will give way.
Gentlemen, for giving way. If the principle of removal to a safe third country is not an adequate deterrent, why was that principle the flagship of the last Labour government's immigration policy in the 2002 Nationality, Immigration and Asylum Act? What was the point of Section 94, its most controversial provision, if it was not about swift removal of failed asylum seekers?
I thank her for her intervention. The crucial point here is that for a deterrent to be effective, it has to be credible. A deterrent that's based on 0.3% risk of being sent to Rwanda is completely and utterly incredible. The only deterrent that works is a returns deal with mainland Europe that is comprehensive. When you know that if you come here on a small boat, you will be sent back to mainland Europe, you will not come. You will not pay €5,000 to the people smuggler. Now, the only way to get that deal is to have a sensible and pragmatic negotiation with the European Union based on quid pro quo give and take. That is the fundamental reality of the situation in which we find ourselves. But unfortunately, the benches opposite keep closing their ears to that reality.
Continue to press on. I'm grateful to the honourable gentleman for giving way. Does he not accept in reality that there's no such thing as a returns deal with mainland Europe? The reason why the Dublin Convention was such a disaster and never resulted in us removing more people than we took in, because it was so incredibly difficult to get European countries to accept removals and to make that happen. This is just a sort of unworkable suggestion.
Surely the Honourable Lady sees the direct connection between us crashing out of the Dublin regulation because of the utterly botched Brexit of the government that she speaks for, and as a result of that, small boat crossings started to skyrocket. There is a direct correlation between crashing out of the Dublin regulation and skyrocketing small boat crossings. I really do hope she'll look at the data and she will realise the truth of the matter.
To the honourable gentleman, because we've had this conversation before. He knows when we were covered by Dublin, before we came out through Brexit, there were over 8,000 requests for people to be deported back to an EU country. Only 108 of those, about 1.5, were actually granted. So there wasn't some golden era where it worked under Dublin. It wasn't working then, and it's certainly not going to work now.
Yes. He's right, we have had this conversation before, and he consistently refuses to listen to the fact that the Dublin regulation acted as a deterrent. So the numbers that he talks about were small, but the number of small boat crossings were small when we were in the Dublin regulation. We left the Dublin regulation. The numbers are now large. It's not rocket science. There is a clear connection, a correlation, a causal link between the two. So turning first, I will give one.
Extremely grateful. He's been very generous with his time. But isn't this not the point? The reason that the small boats problem has grown exponentially is that we dealt with the lorries issue.
Exactly.
We closed the loophole when it came to lorries and the Channel Tunnel in particular, and that is why people are now resorting to small boats. Nothing to do with Dublin.
Exactly.
Surely those are the facts.
Exactly.
Well, I simply say to the honourable and learned gentleman that if you take the numbers that were coming here illegally, of course, those coming in clandestine means in the back of a lorry, far more difficult to detect than those coming on a small boat. By definition, the small boats crisis is far more visible. But the reality is that last year we had 45,000 people coming on small boats, and goodness knows how many coming on lorries. It's true that the juxtaposition and the new arrangements did have a positive impact, but we still don't know how many are coming. I myself have been to camps in Calais and spoken to many who are planning to come on lorries, not on small boats, not least because it's a far cheaper alternative. So the reality is there is a very large number of people coming to our country through irregular means, but it is also clear that that number was significantly smaller when we were in the Dublin regulation, and that's because it was a comprehensive deterrent rather than the utterly insignificant power of the Rwanda programme as a deterrent. I'm going to make a little bit of progress, and then I'll allow the honourable gentleman. Turning first to Lord's Amendment 1B on ensuring this bill is consistent with international law, which we on these benches fully support. Last week, the Minister deemed this amendment unnecessary, and I quote, because it goes without saying that the government obeys our international obligations, as we do with all pieces of legislation. This comment really was typical of the Minister's approach. He's constantly trying to calm his colleagues' nerves by fobbing them off with this sort of soothing statement. But we all know that he doesn't really believe a word of it himself. He knows that the very first page of this bill states that the government is unable to confirm that it complies with our legal obligations. And he also knows that the government is more than happy to break international law. Just look at how they placed fast and loose with the Northern Ireland Protocol. So if the Minister really thinks that we will simply take his deeply misleading words at face value and trust him and his colleagues to uphold our legal obligations, then he has another think coming.
Order. I think that the honourable gentleman didn't mean to use the phrase deeply misleading. I think perhaps knowing that he is an honourable gentleman, that he might want to use a slightly different phrase, inadvertently misleading, perhaps?
I thank you, Madam Deputy Speaker. Would misleadingly soothing work as a...
It will do for the time being.
You are very gracious, as always, Madam Deputy Speaker. Madam Deputy Speaker, the late, great Dennis Healey famously advised that when you're in a hole, you should stop digging. And he would certainly... hang on. And he would certainly have approved of Lord's Amendment 9B, which goes right to the heart of the fundamental unworkability of this bigger backlog bill and seeks to prevent it becoming the indefinite limbo bill. Because let's be clear, the current state of affairs represents both a mental health crisis for asylum seekers and a financial crisis for the British taxpayers, who are already shouldering an asylum bill which is 7 times higher than it was in 2010, at £3.6 billion a year. Indeed, the mid-range estimate for the hotels bill alone is even greater than the latest round of levelling up funding and 3 times higher than the entire budget for tackling homelessness in this country. Madam Deputy Speaker, the only people who benefit from the inadmissibility provisions in this bill are the people smugglers and the human traffickers who are laughing all the way to the bank. So it's essential that this House votes in favour of Lord German's amendment, which seeks to ensure that inadmissibility can only be applied to an asylum seeker for a period of 6 months if they have not been removed to another country. Madam Deputy Speaker, a major concern throughout the passage of this bill has been the utter disregard for the mental well-being of unaccompanied children, many of whom will have had to see their loved ones suffer unspeakable acts of violence. And yet, despite the government's concession, this legislation will mean that when they arrive in the UK, they'll be detained like criminals for up to 8 days before they can apply for bail. We are clear that this is unacceptable, and we're in no doubt that the government's amendment is yet another example of its liking for performative cruelty. We urge the Minister to accept the Lord's compromise of 72 hours under Lord's Amendment 36C and 36D. So I meant to let him in.
I thank the Honourable Member for giving away, but would the best thing for any person's mental health, especially children's mental health, is not to put them on a dangerous small boat across the Channel? It is not going to be the best thing for any child's mental health is they don't make that dangerous journey, use one of the many legal and safe routes. And this bill and these clauses actually make sure that fewer children make that awful journey.
It's absolutely right that the only people who benefit from the small boat crossings are the people smugglers and the human traffickers, and they have to be brought to an end. Where we fundamentally disagree is the means. We believe that the deterrence of the Rwanda scheme simply won't work for the reasons that I've already set out, and the solution lies far more in pragmatism and quiet diplomacy, working with international partners to get that returns deal that I talked about, rather than all the performative cruelty that we're seeing at the heart of this bill. Likewise, they should show some humility and support Lord's Amendment 33B, which states that accompanied children should only be liable for detention for up to 96 hours. This is a fair and reasonable compromise, given that initially Lord's Amendment 33 set the limit at 72 hours. And whilst we're on the subject of children, how utterly astonishing and deeply depressing it was to hear the Minister standing at that dispatch box last week and justifying the erasure of Disney cartoons on the basis of them being age appropriate. Quite apart from the fact that his nasty, bullying, performative cruelty will have absolutely no effect whatsoever in terms of stopping the boats, it's since emerged that more than 9,000 of the children who passed through that building in the year end to March 2023 were under the age of 14. Now, given that a significant proportion of that 9,000 would be younger still, I just wonder whether the Minister would like to take this opportunity to withdraw his comments about the age appropriateness of those cartoons. No. Well, there we have it, Madam Deputy Speaker. This whole sorry episode really was a new low for this Minister and for the shameful, callous government that he represents. Madam Deputy Speaker, we also support Lord's Amendment 23B, a compromise in lieu of Amendment 23, which seeks to protect LGBT asylum seekers from being removed to a country which persecutes them for their sexuality or gender. The Minister last week claimed that the clause was unnecessary because there's an appeals process, But why on earth would he put asylum seekers and the British taxpayer through an expensive and time-consuming appeals process when he could just rule out this scenario from the outset? Madam Deputy Speaker, nothing illustrates the indifference of this government towards the most vulnerable people in society more clearly than their treatment of women being trafficked into our country for prostitution. I've already described this bill as a trafficker's charter, a gift to the slave drivers and the pimps, because it makes it harder for victims to come forward and therefore more difficult for the police to prosecute criminals. The Immigration Minister last week repeated the false claim that the National Statistics Authority rebuked him recently for, his second rebuke this year by our National Statistics Watchdog for inaccurate claims made to this House. And thankfully, the Right Honourable Member for Maidenhead called him out on it. She's not in her place, but she correctly pointed out that the proportion of small boats migrants claiming to be victims of modern slavery stands at just 7%. This was a profoundly embarrassing moment for the Minister, but I do hope that he'll now swallow his pride, listen to the wise counsel that he's receiving from the benches behind him, and accept Amendment 56B in the name of Lord Randall.
Well, grateful to him for giving way, and he is right that I misspoke when quoting those statistics on an earlier occasion. But in fact, the statistics were worse than I said to the House. What I said was that of foreign national offenders who are in the detained estate on the eve of their departure, over 70% of them made use of modern slavery in order to put in a last-minute claim and delay their removal. It wasn't just FNOs. It was small boat arrivals. So the point I was making was even more pertinent, and one that he should try to answer. What would he do to stop the 70% of people who are in the detained estate who were trying to get out of the country from putting in a frivolous claim at the last minute?
Well, the National Statistics Authority, Sir Robert Choate, said clearly that it's only 20%, not 70%. So, I mean, I don't know whether we want to maybe invite Sir Robert to clarify those points himself, but that's pretty clear from the rebuke that the Minister received from the NSA. Because it is vitally important that the Minister's position on this isn't being used as the basis for a policy which could cause profound harm to vulnerable women whilst feeding criminality within the United Kingdom. I'd therefore urge him to reflect on what he's trying to achieve, the proportionality of his actions, and the unintended consequences that he might be facilitating. Lord's Amendment 56B states that victims of trafficking who have been unlawfully exploited in the UK should be protected from the automatic duty to remove and should continue to be able to access the support currently available to them, but only for the duration of the statutory recovery period, which was set by the Nationality and Borders Act at 30 days. During our debate on second reading of this bill, the Right Honourable Member for Maidenhead argued that the bill as drafted would drive a coach and horses through the Modern Slavery Act, denying support to those who've been exploited and enslaved, and in doing so making it much harder to catch and stop the traffickers and the slave drivers. We strongly agree with her concerns and wholeheartedly support Amendment 56B, which I would remind the Minister goes no further than to maintain the status quo in terms of the basic protections and support currently available to all victims of trafficking and exploitation. Madam Deputy Speaker, I now turn to the amendments that are underpinned by Labour's five-point plan to end the dangerous small boat crossings, defeat the criminal gangs, clear the backlog, end extortionate hotel use and fix the asylum system that the Conservatives have spent 13 years destroying. I will give way.
Very grateful. I mean, presumably it's the devoutest hope of the Honourable Gentleman in 15 months' time he takes power, but what's a bit of a mystery to me is, charming as he is, why does he think in 15 months' time, when he asks President Macron to take these people back, he will take them back? Of course he won't. Nothing will happen. So may I gently suggest to him that if there is a Labour government, they will quietly adopt this bill when it's an act?
Well, I'm coming on to that in my comments, but I will say to him that, as he will know, any negotiation requires give and take, quid pro quo. As I already said in response to one of his honourable friends, the point is that to get that deal with the European Union, we, of course, have to do our bit, take our fair share, And that will be the negotiation that my Right Honourable friend, the member for Holborn and St Pancras, will be leading on when he becomes the Prime Minister of the United Kingdom following the next general election. Madam Deputy Speaker, we are determined that the National Crime Agency be strengthened so that it can tackle the criminal gangs upstream. Too much focus by this government has been on slashing tents and puncturing dinghies along the French coastline, whereas Labour has set out its plan for an elite unit in the NCA to work directly with Europol and Interpol. The latest amendment from Lord Coker, 106B, attempts to strengthen the NCA's authority, and we support it without reservation. We're also clear that there's a direct link between gaining the returns agreement we desperately need with the EU and creating controlled and managed pathways to asylum, which would allow genuine refugees to reach the UK safely, particularly if they have family here. The benches opposite refuse to make that connection, but we know that it is in the EU and France's interest to strike a returns deal with the UK to dissuade the tens of thousands of asylum seekers flowing through Europe and ending up on the beaches of Calais. But the EU, I will give way in 1 second, but the EU and its member states will of course never do a deal with the UK unless it's based on a give and take arrangement whereby every country involved does its bit and shares responsibility.
I thank the spokesperson for giving way. On his visit to Calais, he will have met people who were trying to get to this country. Did it strike him how utterly desperate many of them were and how they are fleeing from wars in Afghanistan, Libya, Iraq and other places? And does he not think there is a wider issue here that we've got to address about the very reasons why people are fleeing and searching for asylum, not just in Europe, but all over the world?
I thank my right honourable friend, and the key point, of course, as he rightly points out, is that these are people who already are fleeing desperate situations and have risked life and limb to get as far as well they've got to. So the idea that a 0.3% chance of being sent to Rwanda acts as a deterrent is clearly for the birds. But I know that in addition to that, he's making very important points about the need for international cooperation and for finding solutions to these problems alongside our partners across the Channel. But with the Minister, I will.
I thank the honourable gentleman. I thank the honourable gentleman for weighing. He clearly thinks the Rwanda plan will not work and will not be a deterrent. So my question to the honourable member is, why not give it a go? If you're so confident it's not going to work, let it get through. It could have got through months ago, and then come back to the House and prove us wrong. But at the moment, to me, it comes across the honourable member and the Labour Party are scared that it might work, and that's the problem.
I suppose the answer to his question is that if it walks like a duck and quacks like a duck, it probably is a duck. And the Rwanda plan is so clearly and utterly misconceived and misconstrued and counterproductive. We on these benches like to vote for things that are actually going to work, and that's why we simply can't support that harebrained scheme. But with the Minister last week reiterating a deadline of December 2024, 18 months' time from now, to lay out what safe and legal routes might look like, and by stating that these routes will not deal with the challenges facing Europe directly, he appears to be reducing the chances of getting the returns deal with the EU that we so urgently need. Let's not forget that this government sent Britain tumbling out of the Dublin regulation during their botched Brexit negotiations, and it's no surprise that small boat crossings have skyrocketed since then. This government must prioritise getting that returns deal. We therefore support Lord's Amendment 102B, which demands that the government get on with setting out what these safe and legal routes might look like, both to provide controlled and capped pathways to sanctuary for genuine refugees, but also to break that deadlock around negotiations with the EU over returns. Madam Deputy Speaker, I should also note that the Minister loves to trot out his lines about Ukraine, Hong Kong and Afghan resettlement schemes. He is, of course, neglecting to mention that there are now thousands of homeless Ukrainian families, and the travesty that thousands of loyal to Britain Afghans are set to be thrown onto the streets at the end of August. But also that there are more than 2,000 Afghans stuck in Pakistan with a right to come here who aren't being allowed to. So he simply must fix those resettlement schemes. Yet he also... I will give way.
I'm grateful to give way, because it's an important point that all members of this House should appreciate. The number one reason why there are people in Pakistan who we would like to bring to the United Kingdom because we have a moral and historical obligation to, but are struggling to do, is because illegal immigrants on small boats have taken all of the capacity of local authorities to house them. So if he truly wanted to support those people, he'd back this bill, he'd stop the boats, and then he would help us to bring those much-needed people into the United Kingdom.
It beggars belief that the immigration minister, who speaks for a party that has allowed our backlog to get to 180,000, costing £7 million a day in hotels, just get the processing system sorted out. The Conservatives downgraded the seniority of caseworkers and decision makers in 2013-2014. Surprise, surprise, productivity fell off a cliff. The quality of the decisions fell off a cliff. That is the fundamental problem. But what we do have to recognise that these Afghans are people that have stood shoulder to shoulder with our defence, diplomacy and development effort in Afghanistan, and we owe them a debt of honour and gratitude.
Does the honourable gentleman know how many asylum seekers are housed in his constituency? Or would he like me to tell him? None. None. There are no asylum seekers accommodated in Aberavon. So if he would like us to bring in more people, whether on safe and legal routes or on schemes like ARAP, get on the phone to his local council and the Welsh Government this afternoon.
Well, he's talking absolute nonsense. I'm very proud of the fact that we have many Syrians in our constituency. We have Ukrainians in our welcome centre. The discussions have also been ongoing with the Home Office. I know that, and between the Home Office and the Welsh Government. If the incompetence of his government isn't managing to actually house it, Wales is absolutely ready to have that dialogue with the Home Office.
Grateful to my honourable friend giving way. I find it quite a shocking admission from the Minister, the fact that we know and we are fighting for relatives of people in Afghanistan at this time whose lives are at risk, that they are being blocked by the Minister because he is not making available those safe routes to bring them into constituencies like in York, where we really do welcome refugees.
I completely agree with my honourable friend, and I do think that there are real concerns about the safety and security of those Afghans who are now in Pakistan. It's possible that they will be sent back. Of course, it's up to the Home Office to facilitate their transfer to the United Kingdom under ARAP and ACRS, but like so many things with this Home Office, it is just a catastrophic failure of management. Now, in trotting out the lines about the schemes that I mentioned, the Minister also conveniently ignores the fact that none of those schemes help those coming from other high grant rate countries in the Middle East and Sub-Saharan Africa. And neither he nor the Home Secretary have been able to adequately answer that question from their own backbenchers on that precise point. Madam Deputy Speaker, the final point of our plan is to tackle migration flows close to the conflict zones where they arise through targeting our aid spending. This is a longer-term mission, but it is no less important than any of the other steps we need to take to meet these migration challenges. I therefore see no reason for the Government not to support Lord's Amendment 107B in the name of the Archbishop of Canterbury, which instructs the Government to develop a 10-year plan to manage migration. Madam Deputy Speaker, I've lost count of the number of times we've come to this chamber to debate the Government's latest madcap bill or harebrained scheme. But not one of these bills has helped to stop a single boat. And they've sent more Home Secretaries to Rwanda than they have asylum seekers. They're wasting their own time, they're wasting the time of this House, and they really are trying the patience of the British people. It really is desperate stuff, and it has to stop. So in stark contrast to the hopeless, aimless and utterly self-defeating thrashing around that has come to define this government's approach to the asylum crisis, we on these benches recognise that there is a way through this. It's a route based on hard graft, common sense and quiet diplomacy. It comes in the form of the Labour Party's comprehensive plan, based on core principles, a commitment to return asylum processing to the well-managed, efficient, smooth-running system we had prior to the catastrophic changes brought in by Conservative ministers in 2013, which downgraded decision-makers and caseworkers, resulting in poorer results. And with this, a commitment to go further in fast-tracking applications from low grant rate countries so we can return those with no right to be here, and in fast-tracking applications from high grant rate countries so that genuine refugees can get on with their lives and start contributing to our economy, enriching our society and culture. And a third key principle is the need for international cooperation, as I've already set out. It is not rocket science, Madam Deputy Speaker. It's just sensible, pragmatic, serious governance. And it's working in the United States. The Biden administration is winning the battle. They've introduced a combination of swift consequences for those who cross the border illegally, orderly paths and controls on who and where migrants get to apply for asylum, sensible legal pathways for high grant rate nations, and strong cooperation with Mexico. The result, they're bringing numbers down significantly and quickly. The challenge is not over yet, and you wouldn't see President Biden foolish enough to go boasting at the border. But it shows that progress can be made. The Labour Party is not interested in performative cruelty, chasing headlines, or government by gimmick, Madam Deputy Speaker. But we do have a plan that will stop the boats, fix our broken asylum system, and deliver for the British people. In contrast, the party opposite has run out of ideas and run out of road. It should get out of the way so that we can get to work. Thank you.
We have only 1 hour left for the remainder of this debate, so I have to impose an immediate time limit of, I was going to say 6, but I'm now going to have to say 5 minutes. 5 minutes. Tim Lawton.
Madam Deputy Speaker, it's always an experience to follow the honourable gentleman. It was once said of somebody who'd met his father that they just spent half an hour having a 5-minute conversation with him. Well, we've just had a half an hour speech. We didn't get 5 minutes of anything remotely new within that, I'm afraid to say. Can I declare my interest?
Is it in order to raise the issue of my father and what he might or might not have said when he's not in the chamber to defend himself?
It would be better not to, but there is no hard and fast rule since the Right Honourable and noble gentleman is no longer here. Here in the chamber.
I'll happily withdraw that, Madam Deputy Speaker, if I have my minute back. Can I declare an interest as Chairman of the Safeguarding Board of a Children's Company? Now, I read in the papers over the weekend, I was rather surprised in the briefings, that the Right Honourable Member for Maidenhead and I are some sort of ringleaders against this bill. Can I make it absolutely clear? I support this bill. I want this bill to go through as quickly as possible, and I support the Rwanda scheme. Objecting to some of the trafficking measures in the bill is about protecting victim and prosecuting traffickers, not undermining the bill. Having greater safeguards on how we look after children who've arrived here don't undermine the bill, they strengthen it. Safeguards to make sure that safe and lawful routes for genuine asylum seekers are in place does not undermine the bill, it strengthens and justifies the measures against those who are gaming the system to whom we don't have a duty of care. I just, in the limited time, want to concentrate on the amendment by Baroness Mubarak, and I thank also Baroness Stroud and Baroness Randall for the amendments to do with trafficking and safe and legal routes. The fact is, Madam Deputy Speaker, that the government amendments to Clause 12 would give a child in the UK on their own the chance of applying to be bailed from detention after 8 days. But this would only apply if they're being detained to be removed to be reunited with family or to be returned to their home country. This will not apply to all unaccompanied children when they first arrive in the UK. It would only impact a very small group of children. Other separated children not subject to removal will be detained for at least 28 days, and there's still no statutory limit on detention for any separated child. Under the government proposal, separated children affected by this bill can still be indefinitely detained, and that's the truth of the matter. And it's imperative to include a time limit for child detention on the face of the bill. If the government intends to detain children for the shortest possible time, then they can reinforce this message by enshrining a time limit on the face of the primary legislation, as we've asked for all along. And although the Minister has given some concessions, we are still not there. The government still do not explain what would constitute an age-appropriate detention facility at the same time, have introduced broad new powers which will allow the Home Secretary to designate a place to be an immigration detention centre, and it is worrying to read that the government is still unclear on what will be the status of separated children who are detained, and claims that they will not require support from local authorities under the Children Act 1989. They should therefore have access to support and rights afforded under the Children Act, and it's concerning to see the creation effectively, Madam Deputy Speaker, of a two-tier system where a group of children might be denied protections just because of their immigration status and mode of arrival, despite the fact they are all entitled to protections under the Children's Act. The Minister has said he wants to detain children for the shortest possible time. I agree, so any codifying of this would be a beneficial win, surely. We need reassurances on the type of detained accommodation that meets children's home standards and is subject to the same sort of inspections as children's homes have. Now, I missed the Minister's friendly chats over the weekend, as I've been enjoying for the last few weekends. I'm not sure why I was missed out. He did, however, send round some clarifying points, but they don't clarify. There are still too many outstanding questions. He says, where there is no dispute that someone is under 18, they will as quickly as possible be transferred to local authority accommodation. How quick? Where does it say that? He says, where there is doubt that a person is indeed under 18, as they claim to be, they'll be treated as a child while an age assessment is undertaken. Where? How? Such a person will be detained in age-appropriate accommodation as the law already provides. Where is that going to happen? If no such accommodation is available, they will not be detained and will instead be transferred to a local authority as soon as possible. Good. Where does it say that within this legislation? That is the problem. He quotes various inspection reports of Yarlswood, going back to 2008, in defence of what the government's trying to do. In that inspection report, it said the plight of detained children remained of great concern. An immigration removal centre can never be a suitable place for children, and we were dismayed to find cases of disabled children being detained and some children spending large amounts of time incarcerated. Any period of detention can be detrimental to children and their families, but the impact of lengthy detention is particularly extreme. It also said that the centre was brighter and better decorated than on our last visit. Clearly they had some cartoons still on the walls there. The problem is, Madam Deputy Speaker, that there have been concessions, but there are still too many answered questions, and we need those extra assurances that what the amendment does.
SNP spokesman Stuart C. MacDonald.
Thank you, Madam Deputy Speaker. We should oppose all 9 of the government motions, and that is precisely what my SNP colleagues and I will be doing this evening. But we also say again, this bill is so appalling that the House of Lords should be stopping the bill in its tracks. And yet, Baroness Jones was the one Speaker in the House of Lords who had the guts to say we should be stubborn about not allowing the bill to go through. As I asked last week, if they aren't going to consider halting this bill, which bill will it be? This bill is about locking up kids, about forcing trafficking victims back to their exploiters, mass detention, closure of the UK asylum system and the trashing of international laws. If they're not going to use their powers to block this bill, a bill which also runs totally contrary to what was in the 2019 Conservative Manifesto, what is the point of the powers and what is the point of the House of Lords? But let us hope that we can salvage something from these final proceedings. On 1B, Madam Deputy Speaker, on our international obligations, if the bill is consistent with our international obligations, then the government cannot possibly have any objections to Amendment 1B. On the other hand, if, as the government has at other times argued, it wrecks a bill to have to be read consistently with international law, then the problem is with the bill and it is not with the amendment. And it's a very good reason in itself for the whole bill to be stopped in its tracks.
Hear, hear.
The revisions to the amendment mean arguments about allegedly incorporating international laws have been addressed, despite the completely unsubstantiated assertion from the Minister in his speech. We've heard lots of strong words about protecting a dualist system of law, but given the government couldn't even make the normal human rights compatibility statement, what we really need is strong action to protect fundamental human rights and the rule of law. And the grouped amendments 7B and 90D are also important in upholding the rule of law because they preserve judicial oversight so that illegal decisions by the government can be properly challenged before they are implemented. It really is as simple and fundamental as that. The government keeps talking about loopholes, but access to courts, the rule of law and fundamental rights, they are not loopholes, they are fundamental principles that we should be upholding. Madam Speaker, 9B is another crucial amendment. It now includes safeguards to assuage the usual government concerns about gaming of the system, but retains the vital protections that if a person cannot be removed to Rwanda even after 6 months, they will then have their case assessed here. It simply preserves the status quo and it's an essential protection. because it remains an appalling prospect that people who are refugees are going to be left in limbo forever by this government, never allowed to have their claim heard here and never able to contribute, and even if removal is a near impossible prospect. And indeed, it's also ludicrous that there will be people who have totally unfounded claims for asylum who are going to get to remain here in limbo, often at considerable taxpayer expense because of this bill. Because the bill stops unfounded claims being dealt with, just as it stops well-founded claims being dealt with, on the other hand. So the end result is that thousands of people are going to need to be detained and accommodated in perpetuity. Many more will disappear underground as they have no reason to stay in touch with the Home Office. It is the end of the UK's contribution to the Refugee Convention. And again, if the government is not willing to move on this, their lordships should hold up the whole bill. Hear, hear. On mass and limitless detention of children and inappropriate accommodation, of course, we continue to support all efforts to curtail these horrendous new powers and to limit the extraordinary harm that we know and the Home Office knows detention causes to them. So we support 33C and D and 33B. And as I said last week, the government's amendments in lieu really represent a pathetic non-concession. A theoretical right for some kids detained for removal to seek bail after 8 days is just not remotely acceptable. At the very least, we need short, hard and fast limits, and those limits should be automatic and not dependent on a child being able to navigate a bail system and accessing the legal support that would be required to do that. And these time limits should apply to all kids, whether accompanied or not, and regardless of which particular powers they were detained under. Government makes claims about creating incentives to play the rules, but as with most of the government's claims, they offer absolutely no evidence. There's no suggestion, for example, that the introduction of strict time limits by David Cameron's government had the impact that is suggested here. It's just another myth. Madam Speaker, as members on both sides have said, this bill is a serious threat to modern slavery and trafficking victims, and it totally ignores devolved powers on this subject yet again. Those being exploited are the ones who are going to suffer, not the traffickers whose power over their victims will only be enhanced by the withdrawal of any route to safety for those that they are exploiting. So we support 56B and anything that will undo some of the damage that the bill is going to do to modern slavery and trafficking provisions. Without 56B, the damage this bill will do to slavery and trafficking laws across the United Kingdom is yet again sufficient to justify holding up the whole bill. On 23B and protections for LGBT people, we fully support everything Lord Etherton said in support of his amendments. Put the fact that these countries are not safe for LGBT people on the face of the schedule.
Hear, hear.
Anything that builds on the flimsy and almost certainly unworkable system of suspensive claims should be welcomed. And LGBT people should not have to go through that process in the first place. Madam Speaker, if the Government is committed to safe legal routes, it should have no problem with 102B. And on the Archbishop's amendments 107B and C, a 10-year strategy is utterly sensible. Indeed, it is essential. Long-term thinking is as necessary for issues surrounding forced migration as other pivotal challenges like climate change. But ultimately, Madam Speaker, these amendments can only add a little polish to an odious bill that is utterly beyond redemption. It should be stopped in its tracks entirely, and any parties that still send people to the relic of a second chamber should be using their influence to make sure that happens. Otherwise, this is all just for show, and very vulnerable people are going to suffer as a result.
Hear, hear. Well,
Sir John Hayes.
I'm very grateful, Madam Deputy Speaker. Edmund Burke said that what matters is not what a lawyer tells me I may do, but what humanity, reason and justice tell me I ought to do. And in considering the Government's response to the Lord's amendments, it is important to re-emphasise that this bill is about fairness, about affirming the integrity of our nation by defending our borders from those who seek to arrive here illegally. We must have the power to remove those entrants from our country. To do so is just and fair. It's what the British people expect. It's what they voted for in 2019 and what they chose in the Brexit referendum. Considering the arguments in the other place, I was struck by the absence of a credible alternative to the Government's proposal. There seems little sense there of the need to control our borders, stop the boats, save lives and make our immigration system fairer, more reasonable and just. Indeed, sadly, much of the debate on the amendments in the other place has been characterised by a combination of denial and detachment from the popular will. Denial about the urgency of the problem and detachment from the sentiments expressed by my constituents and my own constituents of members across this chamber. Those arriving in small boats must be detained securely and removed swiftly. That must be a straightforward process, and it is only by doing so that we will deter more people from arriving. Turning to the specific, I won't actually because of the time, but I apologise for the late. Turning to the specifics of the amendments, the government's response to Lord's Amendment 1B, 7B and 90D, as the Minister has made clear, is rooted in an understanding that those amendments are unnecessary. The government take our international obligations very seriously, and indeed the appeal court judges agreed, all three of them, that in terms of the issue of law, the government's commitments are in tune with, compatible with international law. In terms of the amendment, disagree with the Lord's Amendment 23B, we must keep our perspective. There's no evidence whatsoever that the vast majority of people, indeed a significant number of people coming to this country in small boats, are seeking shelter from persecution because of their sexuality. It's a distortion to pretend otherwise. In terms of the government amendment to disagree with Lord's Amendment 102B, this business of safe and legal routes is again a distraction, a detachment from the urgency of this problem. It's not necessarily the amendment. It seems to be legislative grandstanding. Under Section 1 of the Crime and Courts Act 2013, the NCA's functions already extend to combating all types of organised crime, including organised immigration crime. And finally, on the government motion to disagree 107B and 107C, the 10-year strategy by the Archbishop of Canterbury. Well, I approve of the idea of having Lords Spiritual in the other place. They are otherworldly. The Lord Bishops understandably take a view about an infinite, eternal future. But those of us elected and answerable to the people in a direct way have to deal with this world here and now. And in this world here and now, people demand that we control our borders, and they do so justly and reasonably, Madam Deputy Speaker. Well, I won't give way because I do want to finish promptly, and the Deputy Speaker would expect me to do so. The great Tory Prime Minister Benjamin Disraeli said that the secret to success is constancy of purpose, and this Minister and the Home Secretary have been constant in their purpose of controlling our borders. Now, let's have less sanctimony and more common sense, less self-righteousness and more selfless commitment to the people's will, less soul-searching and more heartfelt advocacy of the interests of hard-working, law-abiding, decent, patriotic Britons who support this bill, oppose the Lord's amendments, which is the way I shall be voting this evening, Madam Deputy Speaker.
Alistair Carmichael.
I regard the right honourable gentleman who just spoken as a friend in the true sense of the word, but I say it's a pleasure to finish him this evening, not least because it means he stopped talking. There's a real sense of déjà vu about the debate here, and it's not just because of the proceedings in relation to this bill. We've heard all these arguments before, almost word for word, everything that the Minister advanced at the dispatch box tonight or this afternoon had all been heard in relation to the Nationality and Borders Act, as it now is. And what progress has been made as a consequence of that? Nothing. I was following closely, Madam Deputy Speaker, your exchange with the Shadow Minister in relation to the question of the Minister being misleading. I should say I do not think for 1 second that the Minister was in any way misleading. I can't speak for his intention, of course only he knows that, but I certainly wasn't misled, and I think that to any reasonable-minded person it must surely be obvious what the government is about here today. Look at the broader context here. We have net migration figures that are going up and up. We have today an announcement that construction workers are now to be added to the shortage occupation list, something that runs virtually contrary to every piece of rhetoric we've heard from the backbenchers and the Treasury bench on that side. So what we've got here is a piece of doubling down at the expense of some of the most vulnerable people in the world. The Minister spoke about late and repeated challenges. Well, in order to have a late or repeated challenge, Madam Deputy Speaker, we would have to have some decisions first. You have to have a decision before you can have a challenge. And as of the 28th of March, there were 137,583 applications outstanding in the system to be dealt with. That is the failure of this government. It is to manage migration, whether it is asylum or economic migration that our economy so desperately needs. And that is why we're here today, because it is an attempt, nakedly politically, to deflect attention away from the failure to deal with our system properly. We've heard, unfortunate that the Right Honourable Member for Chingford and Woodford Green is not here, because he made the point perfectly that in relation to modern slavery, the amendments that are under consideration today are ones which would simply put the Minister's own words into force on the face of the bill. Something which, when Conservatives were in opposition, they used to shout about doing all the time. They just seem to have lost their appetite for it in recent times. The point made by the Right Honourable Member for East Worthing and Shoreham in relation to the detention of children were absolutely on point, and we have all seen ourselves, or at least certainly I saw in the time when detention of children was something that was part of our immigration system, the human consequences and the harsh realities of what that actually meant. And it beggars belief that we should be returning to that. The question of safe and legal routes is again a classic example of the government saying to us that we can have jam tomorrow but not today. Why is it that always the high politics has got to be here on the face of the bill, but the actual practical workable solutions, which will, to borrow the Minister's three-word slogan, actually stop the boats, are somehow too difficult? They're always something that's got to be left, not because they're actually practically administratively too difficult, but because they are too difficult because they do not fit the unpleasant political rhetoric and narrative that this government relies on in order to speak to a base that frankly should be confronted and not appeased. That is why my party, when it comes to divisions, will vote against the government motions to disagree, and we would urge their lordships to stick to their guns in relation to this bill.
Sir Edward Lee.
The Minister can relax, and I'm not going to bang on about RAF Scampton. Not least because I put in for the adjournment debate on Thursday, when I can deal with it in more detail. But I just ask the House to accept that my constituents, more than any other constituents in the country, are victims of this farce and this debacle of trying to house 2,000 people in one place, which is not good for them, and it will overwhelm our social services. There is, I think, an argument to be had now about the future of the House of Lords. There's no point in having these endless debates about whether it should be elected or not. It should be a proper revising chamber. But it seems to me that the House of Lords, when it is given a bill like this, their attitude should be, how can we improve it? How can we make it work better? How can we remove these legal glitches which will have unintended consequences? But it seems to me that much of the debate in the House of Lords and the amendments that we've had have just been designed to drive a coach and horses through it and to give even greater prospects to human rights lawyers to develop ever more legal arguments to stop anybody being deported. Now, I do have some sympathy with what the Honourable Member for Auckland said. What is a bit of a mystery to me is we went through this whole process last year. We had this ping-pong, we had the Nationalities and Borders Bill, we got it through Parliament, we were told it was going to solve the problem, and we still have the same problem. And may I just express a prophecy that actually this bill will become law. It will become law because the Labour Party don't want to set up a precedent for the House of Lords blocking legislation, unelected House. So they will give in, the House of Lords will deliver this bill, it will become an Act of Parliament. And I have a horrible feeling that this time next year we will be in exactly the same position. Can we rely on the Supreme Court to actually agree that people should be deported to Rwanda. So what are we going to do? I mean, what is more cruel? Is it cruel actually to detain people as soon as they arrive, or is it crueler to do nothing and to have a tragedy in the Channel? Is it cruel to go on letting these people smugglers get away with what they want? And of course, I have enormous sympathy with what my honourable friends say about children. The trouble is that so many of these people who claim to be children are not children. They have to be assessed. And one of the problems we face actually at Scampton, there'll be so many of these people, 20% of the population coming into the camp. There will have to be an army of social workers who will have to determine whether they are children or not. And I have enormous sympathy for LGBT people and being persecuted. But the truth is, the moment you create an exception to say that you can't deport somebody to an African country because of their dodgy record on LGBT, everybody will claim they're LGBT. Of course they will. Well, I would do the same. If I was coming from Iraq, I would say I was a Christian. If I was coming from Syria, I would say I was gay. And this is the problem we face. Every time we try and do anything, human rights lawyers drive a coach and horses through all our efforts. So what are we going to do? I've said now for 2 or 3 years that the only solution, and I suspect the government will be forced into this, they'll be dragged into this within a year, is that we have to have a derogation, if necessary, a temporary derogation in a national crisis from the Refugee Convention, which prevents you from detaining people who claim that they are asylum seekers. We'll have to have a derogation from the Refugee Convention and the Convention on Human Rights. And I'm a member of the Council of Europe. I value the work of the Council of Europe. But the Court of Human Rights is not a Supreme Court like our court. It's not a Supreme Court like the American Supreme Court. It's a fundamentally political body appointed on political grounds. Until we have freedom of manoeuvre to actually have a real deterrent which tells the world that if you land illegally on our shores, you will be detained, and ultimately you will either have to go back where you came from or you will be deported. We will never stop this problem. And it's all right for the Labour Party to talk about safe and legal routes. All right to talk about what they will try and do, but we all know that it didn't work with the Dublin Convention. It won't work when they take power, if they take power. President Macron will not suddenly change his mind. He won't take anybody back. We will be exactly in this position in 15 months' time, if there's a Labour government, the same position as we are now. And I predict that if there is a Labour government, they will simply leave this act on this statute book, pretty well unamended. I just ask the House, my constituency is the victim of all this. What are you going to do? This is utterly debilitating. We cannot go on like this. Please, can we have a plan?
Caroline Lucas.
Thank you very much, Madam Deputy Speaker, and it is sadly not a pleasure to follow the Right Honourable Member for Gainsborough. I think to stand there and talk about leaving or having derogations from human rights laws is exactly what is wrong with this government's approach to this issue and what is wrong with this vile bill. Madam Deputy Speaker, with overwhelming support from across the political spectrum and backed by Conservative peers and religious leaders, including the Archbishop of Canterbury, the other place is absolutely right to have inflicted a string of defeats on this vile, illegal bill. To begin with Lord's Amendment 1B by Baroness Chakrabarti. This amendment should be easy for any decent government to accept because it simply asks for compliance with the rule of law, which is the bedrock of our democracy. But the government is attacking that foundation, forced to admit on the face of this immoral bill that they are unable to say the bill is compatible with the 1950 European Convention on Human Rights. By tabling a motion to disagree, the government is seeking to deny UK judges the right to interpret this law and check it against compliance with the UK's obligations under no fewer than 5 international conventions that we should be defending and not undermining. Now, in the other place, the Minister tried to argue that a previous version of this amendment was trying to incorporate international law into domestic law, and that in doing so, it was an unacceptable change to our legal framework. Now, I don't think that is what the previous version did, but in this version, for the avoidance of doubt, 1B, the amendment is explicit in calling for interpretation of international law to ensure compliance with our international obligations. Indeed, ministers will be aware of the contribution from Lord Hope, who served as Deputy President of the Supreme Court, who last week said that the government that last week said that this amendment is a pure interpretation provision entirely consistent with the way the courts approach these various conventions, and it is entirely orthodox and consistent with principles. So, adhering to the Refugee Convention, the European Convention on Human Rights and other international laws we've signed up to should be non-negotiable. What a terrible state of affairs that the government wants to vote down an amendment seeking compliance with the rule of law. The government's argument is that they say stripping vulnerable people of asylum and other human rights will stop other vulnerable people falling into the hands of people traffickers. This is both morally bankrupt and utterly bogus. Morally bankrupt because human rights are not earned or contingent on a person's conduct or character, or on whether upholding those rights might affect someone else's actions. Human rights are attached to a person by virtue of their humanity. Vulnerable people, including children, are being punished because of presumed future actions of adults. Furthermore, by disagreeing with Amendment 1B, ministers face the charge of hypocrisy as they disrespect international law and undermine migrants' rights at a time of unprecedented international turmoil. Just last week, we had the Prime Minister at a NATO summit absolutely saying that we need to uphold international law against the grotesque breaches by Putin in Ukraine. Well, yes, we do, but let's have a little bit of moral consistency. But as well as being immoral, their arguments about a deterrent effect are bogus and unevidenced. The Home Office's own impact assessment, published just last month, is peppered with caveats about how undeliverable this policy is, including an admission that the delivery plan is still being developed. The lack of evidence on deterrence in that document is glaring. The bill, it says, is novel and untested, therefore we don't know what impact it will have on deterrence. And as I say, and I said earlier, a raft of children's charities pointed out that once routine child detention was ended in 2011, there was no proportional increase in children claiming asylum. And beyond this, there is strong evidence that it is precisely the hostility towards refugees exemplified by this bill and the government's rejection of Lord's amendments to it that fuels the grim and terrible trade in small boats that this government claims that it is against. And so, Madam Deputy Speaker, any member who votes to block the Lord's amendments should admit that in doing so, they degrade the rule of law. They dehumanise vulnerable refugees. They attack our modern slavery laws. They put LGBT refugees at grave risk, and they lead to the unconscionable mass detention and treatment of children with no stated time limit to that detention. It is truly sickening. I will be voting to uphold the Lord's amendments to this bill because this is a bill that shames and degrades our country, our democracy, and this House.
You hear. Jeremy Corbett.
Thank you, Madam Deputy Speaker. I want to speak mainly about Lord's Amendment 1B to follow the member for Brighton and also the remarks of the member for Gainsborough, who I heard make exactly the same argument in the Council of Europe. I must say, to the consternation of most members of the Council of Europe, he argued that Britain had to criticise and walk away from the European Court of Human Rights because one case was found against Britain. Many more cases have been found against almost every other country who has signed up to the Convention of the European Convention of Human Rights and therefore the court. I support 1B because what it does is give some protection under the 1950 European Convention, the 51 UN Convention, and then the ones on statelessness, the rights of the child, and on trafficking. It will mean that any decision has to be taken in accordance with those conventions. If the government's opposing those, what message are they actually giving other than they have no respect for international law, no respect for the conventions that we ourselves helped to sign up for and write, and they want to walk away from them? Walking away from them will mean what? That we have no regard for the rights of people who are seeking asylum if the European Court of Human Rights finds us to be wanting in that respect. And therefore, any other country that wants to walk away from the European Convention on Human Rights, Turkey, for example, Poland, Hungary, or others, all of whom have issues with their own legislation in respect of European conventions, we're in no position ever to criticise anybody ever again. And the idea that this country is facing a crisis so severe and so serious that we have to walk away from conventions that were hard fought for and have actually served the human rights of people all across Europe very well is simply ridiculous. The numbers of people involved on a global scale are enormous because of the economic stress around the world, because of the wars, because of environmental degradation and destruction, and because of human rights abuse. That is why people seek asylum. The spokesperson of the opposition, my friend, the member for speaking on behalf of the opposition, made it clear that he himself had been to Calais. I've been to Calais. I've talked to people there. They are utterly desperate. Utterly desperate. That is why they're trying to seek a place of safety. But you know what? People that have sought a place of safety in this country, been granted permanent residence here, have made an enormous contribution to our society. They're working in education, they're working in health, they're working in transport, they're working in the care sector, and we have a massive labour shortage in almost every industry. And so it seems to me rather odd that we're preventing people who have been granted at least the opportunity to apply for asylum in this country, the chance of actually working and making a contribution to the society they've chosen to come to. Other countries have far larger numbers than we do. Germany has taken in far more asylum seekers than this country has. Italy has. And outside of Europe, where all the discussion is taking place, it's usually the poorest neighbouring countries where there is a conflict that have to take very large numbers of people in. For example, Bangladesh has taken in well over 1 million Rohingya people from Myanmar because of the activities of the Myanmar army there, and there are other examples around the world. There has to be a global response to this. The answer isn't to put up barbed wire and surveillance and gunboats and all the rest of it. The answer is surely some degree of international cooperation which recognises our obligation to all people around the world as a global community, and do something about the causes and the source of people seeking asylum rather than the approach that this bill takes. I suspect this bill will probably end up being completely ineffective, and possibly nobody will ever be removed to Rwanda. I hope that is the case, but I'd rather we stopped it here and now and at least passed Amendment 1B, which will then give the opportunity for those whose duty is to protect people's rights to actually have recognition of the conventions that we ourselves have signed up to and have spread around the world to say how good we are at signing up to those conventions. Let's stick to our word and stick to those conventions.
Dame Diana Johnson.
Thank you, Madam Deputy Speaker. As we did not have the opportunity for pre-legislative scrutiny of this bill, and it is being pushed through Parliament very quickly, I'm pleased that the Lords have sent back amendments for us to look again and to consider the unintended consequences of parts of this bill. I want to speak to the amendments around modern slavery. Evidence presented to the Home Affairs Select Committee has revealed the urgent need to open up more escape routes for trafficking victims, including to end what is currently industrial-scale sexual exploitation, as we've heard recently, with women advertised on pimping websites up and down the land in every member's constituency on websites like Viva Street, which allows women to be raped multiple times a day. And if they come forward to the authorities under this legislation, they won't be offered help and assistance. They will be detained and removed. So removing those modern slavery protections will certainly do nothing to do what we all want to happen, which is to bring organised crime groups orchestrating this abuse to justice. So I support Lord's Amendment 56B to maintain the status quo. Secondly, on children, I'm really disappointed that the Lord's amendments on children have not been accepted. Children constitute a small minority of those making the crossing in small boats, arriving often frightened, frequently traumatised and always vulnerable. Such were the concerns of the Home Affairs Select Committee about the current treatment and experience of children who claim asylum in the UK, that we recommended the Government commission an independent end-to-end review of the asylum system as it applied to and experienced by children. Instead of that, the Government is hurrying through a bill to reduce children's rights. No one in this House would want such treatment for their own children, and that's why I support Lord's Amendments 33B, 36C, 36B to remain in the bill. And thirdly, a year ago, the Home Affairs Select Committee published the results of our inquiry into channel crossings and identified a slew of robust measures the government could deploy to stop small boat crossings and create a fair and efficient asylum system. These included the creation of safe and legal routes and international initiatives by the National Crime Agency to combat people smugglers, both of which are the subject of Lord's amendments under discussion today. Stopping the people smuggling gangs will require a raft of carefully crafted, costed, evidence-based strategies like the ones put forward by the Home Affairs Select Committee. And it's for that reason that I firmly support Amendments 102B on safe and legal routes, 103B on the National Crime Agency, 107B and 107C on a 10-year strategy, and 23B on removal destinations for LGBT and other persons. And these measures, and the bill as a whole, must be implemented in accordance with our international obligations as set out in Amendment 1B. Thank you.
Patrick Grady.
Madam Deputy Speaker. A constituency contacted me recently and said I'm speaking an awful lot about immigration and asylum issues in the Chamber. And I suppose that's correct, but then that's because the government allocates so much time in the Chamber to immigration and asylum issues. This is the third major piece of primary legislation on immigration since 2015. But the majority of constituents that get in touch with me, hundreds of constituents on each of these pieces of legislation, tell me just how disappointed, if not horrified, they are at the UK Tory government's attitude to people who come here seeking refuge. And in rejecting all of the Lord's amendments before us today, the government is showing just how hostile an environment it wants to create, not just for asylum seekers, but almost for anyone who wants to come and make their home here in the United Kingdom. The fact that they won't accept Lord's Amendment 1B, which is a considerably softer version of what we discussed last week, demonstrates that. If the government is truly committed to the international conventions listed in the amendment, particularly the 1951 Refugee Convention, then it really should have no problem agreeing that they will form part of the interpretation of the Act when it comes into force. I've also heard from constituents who want to ensure that LGBTQ people who arrive here from places where they can face imprisonment simply for being who they are cannot be removed back to those countries. That's what the Lords are seeking to achieve in their Amendment 23B. Accepting that amendment would save time and public money because otherwise, by the Minister's own admission, claimants would have to make suspensive claims against their removal to their country of origin. And that's what the Minister says he wants to avoid. He wants to avoid loopholes and needless court cases. So in that case, he should be supporting Amendment 23B. The amendments that seek to protect children from indefinite detention and on maintaining human trafficking protection speak for themselves, as does the government's insistence on rejecting those amendments. The government keep asking those of us opposed to this bill for alternative proposals for dealing with irregular arrivals. And these are clearly outlined in Amendments 102B and in the Lord Archbishop of Canterbury's Amendments 104B and 107B. The Minister keeps saying that he wants to establish safe and legal routes. Well, that's what Amendment 102B will require him to do. And I've met many asylum seekers through the Maryhill Integration Network and elsewhere who would have much preferred to have come from Eritrea or Iran or other countries that have been mentioned today through a safe and legal route, rather than the risks and costs and desperation of coming on lorries and boats. And the Archbishop's proposals for a development of a strategy on refugees and human trafficking are actually perhaps the most straightforward and easily implementable of all the clauses and amendments so far. The government regularly accepts amendments requiring it to publish strategies and reviews on all kinds of legislation. But perhaps it doesn't want to support this one because transparency and accountability that would come with requiring the government to undertake a long-term analysis and make a long-term plan in response to global population flows is that it would reveal the true hollowness of the rest of their proposals, the inhumanity and the self-defeating implications of the hostile environment. Millions of people will be on the move in the coming years and decades, fleeing wars that we've financed and climate change that we've helped to cause. And experiences in southern Europe and the American Midwest this week suggest they won't just be moving from the southern hemisphere either. And nobody's saying that the United Kingdom should have completely open borders and take unlimited numbers of migrants. But we have to be prepared to take our fair share, just as other countries welcomed refugees fleeing famine and clearances on these islands not that many generations ago. If government ministers and backbenchers truly respected the role that the House of Lords is supposed to play in the UK Constitution, then they really ought to listen to the messages that their lordships are sending today and in the days to come. But as it stands, Madam Deputy Speaker, people in Glasgow North and across Scotland are listening to the rhetoric of the Conservative government and deciding they want no more of it, and they will be seeking the safe and legal route to independence as soon as possible.
Beth Winter.
Thank you, Madam Deputy Speaker. I'd just like to begin by putting on record my complete opposition to this horrendous bill in its entirety. It is cruel, inhumane. It is going to put people at serious risk of further exploitation, and it is stoking division within our society, and it undermines constitutional principles and human rights. We're here today to focus on amendments. So I want to briefly say that I support all the Lord's amendments before us, but particularly Lord's Amendment 1B, as others have already spoken about, in the name of my friend Baroness Chakrabarty. The amendment sets out the bill's intention to comply with a host of human rights conventions, including with regards to protection of human rights, the rights of the child, and against trafficking human beings. It is vital that we underline our commitment to human rights and, to quote the First Minister of Wales, Mark Drakeford, provide a warm welcome to all of those who seek sanctuary. And this is particularly important as accommodation sites that have been identified by the Home Office for asylum seekers become targets for protest by the far right, and that is happening in Wales at the moment. Amendment 1B is a modest and uncontroversial amendment. The Lords have backed it twice. Over 70 organisations have stated their support. The government must yield and stop voting it down. And if the government are, as they say, confident that this bill is compatible with UK's international law obligations, there is nothing to fear from this amendment. I also want to mention my support for Lord's Amendment 102B in the name of Baroness Stroud, a Conservative peer, establishing a duty to establish safe and legal routes. This is again a modest and uncontroversial amendment, but which could make an unsupportable bill slightly better. We need to go much further. We need to expand safe routes, as organisations like the Refugee Council, Care Calais and the PCS Union have argued, in line with this amendment. And we also need to tackle a backlog with a fair, humane and speedy processing system. The government has lost control over the asylum system. Its stop the boats rhetoric will not stop the boats, because people are genuinely seeking asylum from war and poverty, and nobody would go on a boat risking their lives unless they were desperate. We should be welcoming people to our country. What is contained within this bill is not the type of country that I want to live in, and it's not the type of country that I want my children or my grandchildren to live in. What I and millions of others want is a country and a society which is based on care, compassion, kindness, generosity, respect, inclusivity and, yes, solidarity. I support today's amendments, which should be accepted. But if this bill is passed this week, I know many others in this House, but more importantly outside of this House, will continue to oppose and campaign against this appalling piece of legislation at every opportunity. Thank you.
I have to reduce the time limit to 4 minutes. Claudia Webb.
Thank you, Madam Deputy Speaker. The provisions of this bill are inhumane and punitive. It has not improved with the government's amendments put forward to the other place, which that place has rightly rejected and proposed its counter-amendments. The government remains determined to allow itself to detain and deport even accompanied children, to disqualify many refugees from even attempting to apply for asylum or appeal against unjust decisions, and gives the Home Secretary sweeping powers to make new rules or apply them as the government sees fit. Even if every amendment proposed by the Lords and passed, it would remain an odious bill, and one that shames this House and shames this country. But the latest Lord's amendments do at least mitigate some of the worst harms of the legislation that the Home Secretary cannot even say is legal under international law. For these reasons, I support all of the proposed amendments sent back to this House by the other place, but I wish to speak particularly on the following. The government has rejected an amendment that would place a statutory duty on it to provide safe and legal routes for refugees to reach the UK to apply for asylum on the basis that it's already said that it will introduce such routes. However, a promise to do something is not the same as a legal obligation to do it, and it is clear that this government can barely be trusted to comply with its legal obligations, let alone its promises, as can be seen in the unlawful deportation of members of the Windrush generation, and in the very fact that safe and legal routes do not already exist. The government can provide safe and legal routes when it wishes to. We know this. We are talking about people fleeing war, conflict and torture. British-made bombs forcing desperate people to flee their homes. I'm surprised to learn today that the Minister admits that he's holding up, that they're holding up refugees in Pakistan, refugees fleeing Afghanistan in need of being here. I'm surprised to learn that that is happening. I believe that to be unlawful. If the government is serious that it intends to establish safe and legal routes for all seeking asylum, it has no need to fear or avoid taking or indeed taking on itself a legal duty to do so. Promises of better tomorrow are no substitute. This is not a non-issue. I therefore wish to put on record my support for Lord's Amendment 102B. Secondly, this month, over 150 children's charities, faith leaders, medical bodies and others wrote to the government to demand that it scrap plans to detain refugee children, an abhorrent notion that disgraces this House and brings dishonour on the UK. It's a deeply inhumane and harmful provision of this bill. The idea of detaining children, especially indefinitely, is one that has even horrified some members of the party opposite. Earlier this year, the Honourable Member for East Worthing and Shoreham said of this bill that it amounts to effectively indefinite detention of children of any age, anywhere that the Home Secretary considers appropriate. The Prime Minister has called this bill decent and humane. It's clearly neither. I therefore support Lord's Amendments 36C, 36D and 33B that restrict the detention of children. Given time, Madam Deputy Speaker, thank you.
John McDonnell.
I want to apologise for you. I don't think it indicated clearly enough that I wanted to speak, and I apologise, but thanks for your generous dexterity in finding the time itself. I just want to say one simple thing really about the assurances that have been given so far with regard to the detention of children. I have to say they're not sufficient. There's large numbers of children now who will be detained. The issue with regard to the definition of age-appropriate and children-appropriate accommodation I don't think is clear enough. I go back to I remind the House again of my experience with regard to Harmersworth Detention Centre in my constituency before 2014, and we legislated to prevent children being detained in detention centres. That detention centre was meant to be age and child appropriate as well. And what happened, there was a simple wing and then an education, a school, etc. And children were locked up in there for months on end. And we saw the report of individual civil society organisations doing their assessments about the mental health implications of the detention of children at that stage. So far, what the Minister has told me is that there's no government intention to detain children in detention centres again. As I said to him before, an intention is not good enough. We need something in terms of legislation that will prevent that happening again. My fear is that what will happen under pressure, government ministers will decide that there'll be some appropriate decoration of some sections of Harmersworth, and then it will be opened up for children again. I was a house father of a children's home in Hillingdon, and it was one of the traditional children's homes. Effectively, it's where it was run like a family unit. I pursued my own career. My wife was the house mother in charge and I was the house father. It was like a large fostering unit, basically, and we took in children who'd been detained in Harmersworth, even before it was actually the prison style that it is now. Those children were, I believe, were scarred for life. I didn't think that we'd ever return to the fact that we would lock children up in that way. And my fear is what happened with the children that we looked after. Often they came to us after they'd been lost within the system itself, whilst their cases were being processed over a long period of time, often separated from their families who came through other routes as well. The damage, I think the damage was a scandal on this country's treatment of human beings. That's why from 2010 until 2012, we ran a campaign across all religious groups, civil society organisations, the Children's Society. We published report after report. And David Cameron came forward heroically and said we will never detain children again, and we legislated in 2014. We are now going back. We are now going back to detaining children almost indefinitely for some categories. We haven't got the assurances that we need about where they'll be detained or the care and comfort and succour that they will have to support them. And as a result of that, this legislation, I think, is a stain upon this House if we allow it to go through. And I think it will be a stain upon our society overall for a long time to come. I just ask members to think again. We go back into ping-pong with the other House now. What the other House is calling for is simply a time limit that is realistic with regard to the detention of children so that they're not damaged beyond repair in the way that they were 10 years ago. I don't think that's an awful lot to ask of the government, a simple amendment to set a time limit for the way in which these children will suffer within detention as when they arrive in this country, often, as I've said before, coming from countries where they've suffered enough. We should not impose even more suffering upon them.
The Leave of the House, Minister.
Thank you, Madam Deputy Speaker. And with the leave of the House, let me say a few words in closing this short debate. As I said at the outset, when we met last week and voted 18 times, we supported this bill time and again. On each of those 18 votes, we in this democratically elected chamber voted to stop the boats, to secure our borders, and to enable this important bill to move forwards. Now is the time for the other place, which is at its heart, as a number of our colleagues have said today. Ultimately, I won't give way, we've heard from him a number of times. Ultimately, a revising chamber. It is now time for the other place to support the bill. And today's debate, like some of the others, have been short on new arguments and completely short of any credible alternative. And I go back to the arguments made in the other place by many distinguished members of that House and former members of this House, most notably by the noble Lord Clark, who said clearly that having listened to the debate for hour after hour, he was not able to discern a single credible alternative to the government's plan. And it is incumbent on those who want to vote against this bill to bring forward alternatives, and we haven't heard a single one. I used to say that Labour don't have a plan to stop the boats, but that's not true. They do have a plan, but it's just one that is so dangerously naive that it's a recipe for even more crossings and even greater misery. They would create a massive pull factor by giving economic migrants crossing the Channel from a safe place like France the ability to work sooner. They'd attempt to grant their way out of the problem and sacrifice the remaining integrity of the system. They'd create bespoke country-specific routes for every instance of instability in the world, which would impose more and more pressures on local communities. And wasn't the most telling fact in this debate that in the shadow immigration minister's own town, Aberavon, there is not a single asylum seeker today. So if you want more asylum seekers, have the honesty to have them in your own constituency. And from the letters that I received from Labour MPs, I assumed that they would house asylum seekers even more expensively than we do today, with no regard to the taxpayer. And I'm not clear how they would remove illegal migrants when their own leader campaigned to close an immigration removal centres. Tens of Labour MPs have opposed the reopening of 2 others, and the Labour Party's own membership recently voted to abolish them altogether. The fact is that as they vote against this bill today, their message to the law-abiding people of this country, from Stoke to Blackpool to Peterborough, is quite simply, when it comes to illegal migration, put up with it. Their message to the British families who have to wait longer for social housing or GP appointments is tough luck. And their message to the hard-working taxpayer faced with ever-rising costs of this system is cough up. It's only the Conservative Party that can see the fundamental injustice of illegal migration, that see that it ultimately affects the poorest people in society the most, and actually has the determination to fix it. That's why this bill is so important. That's why the Lords now need to back it, and I beg to move.
The question is that this House disagrees with the Lords in their amendments 1B, 7B and 90D. As many as that opinion say aye. Aye. Of the contrary, no. No! Division, clear the lobby. Order! The question is, this House disagrees with the Lords in their amendments 1B, 7B and 90D. As mayors that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Jacob Young and Julie Marson. Tellers for the noes, Colleen Fletcher and Mary Glindon.
Order. Order.
The ayes to the right, 298. The noes to the left, 213.
Thank you. The ayes to the right, 298. The noes to the left, 213. So the ayes have it. The ayes have it. Unlock. Just remind everybody, it's 8 minutes per division from now on. Order. Order. Under the programme order of the 11th of July, I must now put the questions necessary to bring to a conclusion proceedings on the Lord's message. We now come to the motion to disagree with Lord's Amendment 9B, and I call the Minister to move the motion.
Move formally.
The question is that the House disagrees with the Lords in their Amendment 9B. As many of that have been say aye. Aye. Of the contrary, no. No! Division to the lobby. Thank you very much.
That's never happened.
Order. Order. The question is that this House disagrees with the Lords in their Amendment 9B. As many of that have been say aye. Aye. The contrary, no. Tell us for the ayes, Julie Marston, Jacob Young. Tell us for the noes, Mary Glindon and Colin Fletcher.